8th and 31st interested party.
Yeah, good afternoon, Lord. May please the court in the matter.
Yes.
Here, Wanyama appear together with Bundi and Chalo. They are all present.
Thank you, Mr. Wanyama. The 19th interested party.
Next issue, Lord.
Yes.
That matter, my name is Arwa.
Yes.
Here together with Ms. Grace Minor.
Thank you, Mr. Arwa. The 22nd interested party.
May it please the court,
Yes.
Dr. Kamodo for the 22nd interested party.
Thank you, Dr. Kamodo. For the 32nd interested party.
Next issue, Lord. In that matter, I hold for that particular interested party, I hold break for Ms. Ondieki.
Thank you, Mr. Arwa. Have we left anyone out? Thank you. This matter is for judgment this afternoon. We have two judgments, and we'll be reading them in the course of this session. The consolidated petition is three-pronged. Firstly, it challenges both the constitutionality and process of establishing the office of the Chief Administrative Secretary, hereafter the office of the CAS or CASs. A related argument is that the office of CAS is a state office which can only be lawfully established through an act of parliament. Secondly, the petitioners are aggrieved by His Excellency the President, hereafter the first respondent, and I quote, unilaterally creating additional 27 positions of CASs beyond the 23 that were created on the recommendation, unquote, of the Public Service Commission, hereafter the PSC or fifth respondent. Thirdly, it is contended that the additional offices will impose an unreasonable or additional financial burden on the public, contrary to constitutional and statutory imperatives on prudent use of public resources. The first petitioner prays for various declarations and orders, including nullification of the appointment of all the 50 CASs, the second to 51st interested parties, and declarations that Section 26, subsection 2 of the Salaries and Remuneration Commission Act and the Salaries and Remuneration Commission Remuneration and Benefits of State and Public Officers regulations are unconstitutional. The second and third petitioners, on the other hand, seek, among other prayers, a declaration that the President is bound by the recommendations of the Public Service Commission on creation of an office in the public service under Article 132, Sub-Article 4A of the Constitution, and a declaration that the recruitment process for the interested parties was in violation of the Constitution as well as the Public Service Act. They pray that the appointments of the 50 CASs be quashed. They also contend that the PSC abdicated its mandate under Article 234 of the Constitution by establishing a public office contrary to Articles 10 and 232, and that the process of vetting and approval of the interested parties by the National Assembly would be in breach of Articles 2, Sub-Article 2, 4, 10, 94, 95, 232, and 259 of the Constitution. The fourth petitioner seeks, inter alia, for a declaration that the appointment of the CASs is a waste of public funds and resources. He argued that in the face of the high unemployment levels and economic recession facing Kenyans, the appointments offend Article 10 of the Constitution with specific regard to prudent use of public funds and resources, good governance, transparency, accountability, and sustainable development. A short history of the litigation is relevant. Petition number E080 of 2023, dated the 17th of March 2023, was presented to court on the 20th of March 2023. It was consolidated with petition number E084 of 2023, dated the 23rd of March 2023, as they were largely founded on identical facts and sought similar reliefs. The two petitions questioned the exercise of the President's power under Article 132, Sub-Article 4A of the Constitution in establishing the office of the CAS and the appointment of an additional 27 CASs. On 31st of March 2023, the single judge, J, consolidated the two petitions. She also certified the matter as raising substantial questions of law and referred it to the Honorable Chief Justice for appointment of an uneven number of judges. The present bench was empaneled on 19th April 2023. Petition number E050 of 2023 was subsequently brought by the fourth petitioner on 5th of May 2023. On 23rd of May 2023, the Honorable Chief Justice directed that the petition be heard by this bench. It is imperative to note that on 28th of April 2023, we had read at directions for the disposal of the earlier petitions and set a hearing date. At the hearing on the 25th of May 2023, the bench consolidated the new petition with the other two and issued fresh directions. The read petition remained E080 of 2023. The consolidated petition is strenuously opposed by all the respondents and all the interested parties through some grounds of opposition, various replying affidavits, and notices of preliminary objections that we shall particularize later. We should point out that the President, first respondent, did not file any response to the petitions. However, the Attorney General, second respondent, raised a preliminary objection that the President was wrongly sued and should be removed from these proceedings. The PSC, that is the fifth respondent, on the other hand, did not file a reply but sought to benefit from the affidavit of Felix Koske filed on behalf of the second respondent. We shall deal with the propriety of that matter later. The key objections by the respondents and interested parties are as follows. Firstly, that the issues raised fall squarely within the jurisdiction of the Employment and Labor Relations Court. They thus contend that the High Court lacks jurisdiction to determine the dispute. Secondly, that the issues are res judicata in view of two earlier decisions of the Superior Courts read by Murima J, Inokia Omtatal and another versus PSC and 73 others, 2021, and by Baru J in LSK and two others versus Attorney General and others, 2022. Thirdly, it is contended that the petitions are premature and non-justiciable. Fourthly, that the petitions are poorly drafted and imprecise. Fifthly, that the respondents have not breached the Constitution or any statute. And lastly, that the President enjoys immunity from suit and is thus wrongly enjoined into the suit. On 23rd of March 2023, the single judge, J, granted a conservatory order barring the interested parties from assuming or continuing to act as the CASs. Those orders were confirmed by the full bench in a considered ruling dated the 28th of April 2023. The Attorney General, second respondent, Mr. Dennis Itubi, and Engineer Nicholas Gubo, the 19th and 22nd interested parties respectively, had also lodged preliminary objections to the jurisdiction of the court and asserting that the suit is res judicata. Following directions by the bench on 28 April 2023, the parties agreed that those matters form part of the reply to the consolidated petition and be determined in our final judgment.